Hello, everybody. I had to turn the comments off tonight. Sorry, I just do not have a moderator with me and want to make sure I'm staying within the TikTok guidelines. I'm all about the rules. So, welcome, everybody. I'm going to take just a couple of minutes here before the 7 o'clock time to just make sure that I'm set up okay so everyone can see what I'm doing. I have posted a video. I did go through this earlier and made a set of videos explaining all of the different pieces and highlighting it. So I'll have to, I think there's a total of 5 different posts that I will have up for those videos. So what I'm hoping, I hate turning off comments because I really like answering questions, but being able to go through this in the detail that I need to go through it and watching comments at the same time is just too much for this attorney to do at the same time. So I have posted a video though on the beginning part of this as well as the question for today. So if you have questions, please go to those posts. I'm not sure if the second one has been up yet or not, but please go to that post and just put your question right in there. And after the live, I will go in and answer as many of those questions as I possibly can. So you definitely, I would love to hear any questions that you have and we can go through that information, but just leave them under that particular video as opposed to trying to catch the comments quick enough during the live. I found over the last couple of days, I'm just not quick enough to get everybody's questions answered. But I do want to make sure that if you have questions that I'm available. So please do go and check out that video or just hop off the live, go ask your question and then come back if you want. Whatever works for you. But please know I definitely am open to questions and would love to hear from people. So we will be going through the Presidential Records Code section of the United States Code tonight, and I will just walk us through everything. There are only 9 sections, and it really doesn't take that long to go through it. It gets a little complicated in a couple of different areas, but overall, this particular law is pretty easy to understand. I will be breaking it apart using a color-coded system here that is pretty typical that I've just used over the years in order to make it easier to understand statutory law. In the law, we've got so many different ways of looking at things. So I just use a color-coded system. The colors don't really mean anything. It's just a particular order so I can separate out all the subsections. Sometimes we get into multiple subsections and so it can be difficult to understand. So I just pull them out in a different color and highlight it so that we can stay on track. But I am monitoring to make sure that I stay in frame the entire time. So hopefully you can all just bear with me. Again, I apologize not having comments on tonight, but I really wanted to get through the language of this statute, just each and every single piece of it. So if people have questions, then you can go and ask those on the video that I've already posted, and I will get to those questions immediately after the live. So not as much fun, I know, but it's really, I think, best for following the rules when it comes to lives and guidelines. So I've got a couple more minutes before the official start time, but I'm so thankful for all of you that are joining me tonight. I am a licensed attorney. I have been practicing for a very long time. And I also have been teaching law for a very long time. So my educational background, I have a degree in political science with a minor in rhetoric, which is speaking. So yes, I minored in speaking. And then I did go to a law school that was accredited and did my time there. Then took my state's bar examination, passed that, and it did what I needed to do to get my license to practice in my jurisdiction. So it has been a fun, interesting ride for me, but I do assure you that anyone logging on and anyone in my jurisdiction who knows me can make sure to keep me in check when it comes to making sure the information that I'm giving is accurate and trustworthy. I do my presentations as though my ethics board is watching. So that's what I keep in mind every time I do any video or any presentation. So those are my credentials such that they are. I do like to try to remain partially private as much as I can. I do not have any political affiliation whatsoever on TikTok. That's not why I'm here. I'm here just to give the facts, just to give the law, just to give information, and everyone can kind of form their own opinions and do whatever they want when it comes to their political aspirations, as long as everyone is within the boundaries of the law. I have no problems with any of that. But of course, in my own personal life, I have my own way of going forward when it comes to my political ideologies, but I don't try to lend those to other people, especially when I'm talking about the law. The law, in my opinion, should always be neutral, even though in reality it may not be neutral. It should be neutral. So we'll get started then. We are at the 7 o'clock time. And again, these are just a way I use these highlighters. I have a special purple. Some people may know there's a special purple anniversary going on right now, but I use these colors just to break apart the code to make it easier to read. So you can follow along or watch my videos as they get posted and follow along if you're interested in that. So I'll put these off to the side and we'll get started here. And I'm going to start by explaining where this code section is. We're talking about a federal code here. This is a federal statute. Sometimes we refer to these as acts. It's the same thing in the legal world. But this particular section comes from Title 44 of the Public Printing and Documents Act. So this is a federal United States code section. And under this code section, these are all of the chapters that are listed here. Now, if you go down to 22, what you'll find out is the section we're going to talk about tonight, which is presidential records. So here is the specific section, the chapter of Title 44 that we're going to be going through tonight. Now, if you go online, you can look up Title 44, and then you would put in USC 22, and it will pull up multiple different locations for this kind of law. And what you want to make sure that you have is it's not a summary or a summation. You want to actually find the code itself so that you know you're looking at the proper language. And that code is in multiple places. And anything, the National Archives have it. I'm using their copy tonight. The White House has it. It's listed under congressional acts. So any of those places, you're going to be able to find this federal code section. So again, we've got Title 44, which covers all public printing and documents. And then under that, we're looking at Chapter 22, which is the presidential records section in particular. Okay, so if anyone has questions on where to find that, again, I highly recommend just putting your questions on any of the videos that I've just posted recently on this, and I will try to get to them as soon as possible after the live. So take a look. We've got presidential records under Title 44. And then this is just another page of Title 44 here. Now, this is an example of what you could find when you look it up. This is, again, just another example, and they go through and explain, again, the amendments. So I'm just showing you visually what another format of this would look like if you go and look it up for yourself online. And this is absolutely correct and true to the full language of the law. So this is the code I will be going through tonight and using this as my template to walk through. And again, I'm watching to make sure that I'm in frame. So I will make sure I do my best with that. But again, we've got 44 United States Code Chapter 22, specifically presidential records. And there are 9 sections, which is nice because this won't actually take that long. The details are very well done, and so we should be able to walk through it without too much trouble. This particular copy I got from the National Archives, There's no copyright issue, of course, because this is federal law and available to the public. So I'll go ahead and get started. And again, you'll just see me switching between different colors of highlighters when I'm pulling out different sections of this code section. And that's just to make it easier to follow along and to understand what's going on. A lot of times legal language can get pretty heavy, so I find if you pull it apart with brighter colors, somehow that makes it more bearable. All right, presidential records. Again, I would remind you, I apologize for having to turn comments off tonight, but I just am unable to multitask at that level. But please do leave all comments on any of my videos regarding this topic, and I will go in and get to those questions as soon as I possibly can and try to get to all of them. So, presidential records, 44 United States Code, Chapter 22. At the very beginning, we'll start with the table of contents. So we've got section 2201, which is definitions, 2202, where it goes into ownership of presidential records. So who actually owns these records? 2203, management and custody of presidential records. We'll go into that. 2204, restrictions on access to presidential records. And then, of course, we have to have some exceptions to restricted access. We've got regulations here. We've got 2207 that goes into vice presidential records. So many may not know this, but the vice president records are treated the same that we would treat our presidential records. So those requirements are similarly required. And then we've got a special note on a rule of construction that was added later on to kind of clarify a few bits of this vice presidential records portion. Section 2208, claims of constitutionally based privilege against disclosure. And I have had some questions on whether or not this request for disclosure could be denied or could be refused based off of a privilege against self-incrimination. That's an excellent question. And so this section of the code here will go into that a little bit further so we get more information and an exact reference to this idea of privileged information and whether or not it has to be disclosed. And then we've got section 2209, which is disclosure requirements for official business conducted using non-official electronic messaging accounts. I'm not sure if anyone can think of a reason why we would have this particular section, but it was added on and it is quite detailed. And so I will also be going through that section. Again, all of this is public information. It's all available online and you can look it up under 44 USC Chapter 22. And I'm going to just dive right in. So bear with me. And again, if you've got questions, please feel free to drop them on any of the posted videos so that I can make sure to get to them right after this live. All right, here we go. We're going to get into definitions. Now I am going to do a little bit of commentary as we go along here. Some people like that, some people don't like that. It's just what we're going to do. So bear with me. Section 2201 definitions. Now, every section of every code, state code or federal code, is going to have a definition section. We have a definition section because the exact same word can mean something completely different in another section of the law. Now, all of this is written by Congress. It's passed by Congress. It goes through our system of passing laws. So this is all based off of laws written by elected people to Congress. Okay, so keep that in mind. As used in this chapter, and we'll go through the different terminologies. I'm not going to read word for word every single thing, but I will read some sections that I think are very important. So let's start off with the first term, which is documentary material. And what does that mean for the purposes of this section? Documentary material means all books, correspondence, memoranda, documents, papers, pamphlets, works of art, models, pictures, photographs, plats, maps, films, and motion pictures, including but not limited to audio and visual records or other electronic or mechanical recordations, whether in analog, digital, or other form. So specific to this code, this is what documentary material means. The next one, which I think is really important, is the definition of what presidential records are. So let's take a look at that. It means documentary materials or any reasonably segregable portion thereof created or received by the president's immediate staff, or a unit or individual of the executive office of the president, whose function is to advise or assist the president in the course of conducting activities which relate to or have an effect upon carrying out the constitutional, statutory, or other official or ceremonial duties of the president. Now, when they're defining presidential records, they're talking about the current president, the president at the time that this is being looked at. So as of today, in this moment, who is the president? And that's the presidential record. Now, we do have a section that will go into and explain prior presidents and incoming presidents and what those records are called, but that's what they're clarifying here. So we go to another subsection here, and they're explaining a little bit further what they mean by presidential records. Again, the definition is very important. It includes any documentary materials relating to the political activities of the president or members of the president's staff, but only if such activities relate to or have a direct effect upon the carrying out of constitutional, statutory, or other official or ceremonial duties of the president. So that's another definition again of what presidential records are. And this definition of what presidential records are is key. We gotta know what that is, and for purposes of this particular section of the code. So then we go down to section B, and it explains what it does not include. It does not include any documentary materials that are, and we've got some subsections here. 1, official records of an agency as defined by 552 sub E, Title 5 of the United States Code. So any official records are not seen as presidential records. That's explained right here. Now, subsection 2, any personal records, and they'll go through and explain what personal records are. 3, stocks of publications and stationery. Or 4, extra copies of documents produced only for the convenience or reference when such copies are clearly so identified. So again, we have a very clear and concise definition of what presidential records are and what they are not. That takes us to the next term, which is personal records, subsection 2. The term personal records means all documentary materials or any reasonably segregable portion thereof of a purely private or non-public character, which do not relate to or have an effect upon the carrying out of constitutional, statutory, or other official or ceremonial duties of the president. So this is all other records. So we had presidential records, anything relating to the job as president, and then we have personal records, which is everything else. And then they go through and list them, and I will not read all of this out, but some examples of personal or private personal records would be diaries relating to private political associations, materials relating exclusively to the president's own election to the office of the presidency. So these are some examples of what personal records are under this statute. Next, we've got the definition of archivist. The archivist plays a significant role throughout all of this. And we have archivist means the archivist of the United States. And again, if we go back to the definitions and as we go through ownership, we will see who has ownership of any of these records. And the archivist is a key player with that. Number 5, the term former president. The term former president, when used with respect to presidential records, means the former president during whose term or terms of office such presidential records were created. So we have the current president as of today, and then everyone else is a former president. So any records creating during a different presidential person will be covered under former president terms. Next, we have Section 2202, which clearly sets out ownership of presidential records. So let's go back to our definitions. We've got documentary material, presidential records, and now who owns these presidential records? Let me make sure I'm in frame here. There we go. The United States shall reserve and retain complete ownership, possession, and control of presidential records, and such records shall be administered in accordance with the provisions of this chapter. So this is the section that says who has ownership of presidential records. And the ownership is the United States. So it's not a person. A person does not have ownership of presidential records. It is the country itself that has ownership. Section 2203, management. Whoops, my highlighter. Oh, I've used this highlighter too much. Hold on, stay with me. All right, management and custody of presidential records. So now that we know that these records are owned by the United States, we have to go through the management and custody of those records. So the first piece here, the president, and I'm not going to read line by line here, but the president shall take all such steps as may be necessary to assure that the activities, deliberations, decisions, and policies that reflect the performance of the president's constitutional, statutory, or other official or ceremonial duties are adequately documented. So everything has to be documented properly, and that such records are preserved and maintained as presidential records pursuant to the requirements of this section and other provisions of law. So there's the requirement of what has to happen with specifically presidential records. And that takes us to subsection B, documentary materials produced or received by the president. So produced or received by the president's staff or units or individuals in the executive office of the president, the function of which is to advise or assist the president, shall, to the extent practicable, be categorized as presidential records or personal records upon their creation or receipt and be filed separately. Again, we're going through this explanation of what needs to happen with the records. C, during the president's term of office, the president may dispose of those presidential records of such president that no longer have administrative, historical, informational, or evidentiary value if, go down to our subsections here, the president obtains the views in writing of the archivist concerning the proposed disposal. So they can be disposed of while a president is in office, only if there is permission granted by the archivist. And two, the archivist states that the archivist does not intend to take any action under subsection E, which is down here, of this section. So these two pieces have to be met, and then a sitting president would be able to dispose of some presidential records. Now, subsection D, in the event the archivist notifies the president under subsection C that the archivist does intend to take action under subsection E, the president may dispose of such presidential records if copies of the disposal schedule are submitted to the appropriate congressional committees. So the information has to be submitted to Congress first, at least 60 calendar days of continuous session of Congress in advance of the proposed disposal date. The rest of this goes into more details of those dates, and so I won't spend time going through that language. Then we've got section E. The archivist shall request the advice of the Committee on Rules and Administration and the Committee on Governmental Affairs of the Senate and the Committee of House Oversight and the Committee on Government Operations of the House of Representatives with respect to any proposed disposal of presidential records. So again, we're still talking about any kind of disposal of these records, and that's what these subsections here are for. Now we go into more details regarding the disposal, and I won't spend time reading that, but subsection F, during a president's term of office, the archivist may maintain and preserve presidential records on behalf of the president, including records in digital or electronic form. The president shall remain exclusively responsible for custody, control, and access to such presidential records. Again, the president is defined in this section as the current sitting president. The archivist may not disclose any such records except under the discretion of the president until the conclusion of the president's term of office. If a president serves consecutive terms upon the conclusion of the last term, or such other period provided for under Section 2204 of this title, which we have coming up next. All right, so there we go, some more specifics on that. Now we've got subsection G here, and I'm going to just pull this out so that we can make sure that we follow along and we don't get lost in all of these technical legal bits and pieces. So the last subsection here for 2203 is going to be subsection G1. Upon the conclusion of the president's term of office, or if a president serves consecutive terms upon the conclusion of the last term, the archivist of the United States shall assume responsibility. All right, let me read that again. Upon the conclusion of a president's term of office, or if a president serves consecutive terms upon the conclusion of the last term, the archivist of the United States shall assume responsibility for the custody, control, and preservation of, and access to, the presidential records of that president. The archivist shall have an affirmative duty to make such records available to the public as rapidly and completely as possible, consistent with the provisions of this chapter. And that, again, designates out what is supposed to happen to these kinds of papers after the president leaves office. Down here, they're going to go into the specifics of what the archivist is supposed to do with those records. Now, I'm not going to skip through this because I think this is important information. That was number one. Here's number two. The archivist shall deposit all such presidential records in a presidential archival depository or another archival facility operated by the United States. Now, this again is showing the ownership of that paperwork. The archivist is authorized to designate, after consultation with the former president, a director at each depository or facility who shall be responsible for the care and preservation of such records. Number three, when the president considers it practicable and in the public interest, the president shall include in the president's budget transmitted to Congress for each fiscal year in which the term of office of the president will expire such funds as may be necessary for carrying out the authorities of this subsection. Number four, the archivist is authorized to dispose of such presidential records which the archivist has appraised and determined to have insufficient administrative, historical, informational, or evidentiary value to warrant their continued preservation. Notice of such disposal shall be published in the Federal Register at least 60 days in advance of the proposed disposal date. Publication of such notice shall constitute a final agency action. This is legal terms that we need to know if we need to file forward in court for purposes of review under Chapter 7, Title 5 of the United States Code. So that takes us to Section 2204. We're almost done here, actually. I mean, it's pretty clear cut. So 2204, restrictions on access to presidential records. We'll get into subsection A first. Prior to the conclusion of the president's term of office or last consecutive term of office, as the case may be, the president shall specify durations not to exceed 12 years for which access shall be restricted with respect to information in a presidential record within one or more of the following categories. And we have subsection 1, 2, and 3, and underneath those we have more subsections. So I'm going to just break these apart again just to make it very easy to see all of the different pieces of this statute. So here are the categories. Specifically authorized under criteria established by an executive order to be kept secret in the interest of national defense or foreign policy, and in fact properly classified pursuant to such executive order. So here we've got the discussion of classified records. Next, 2, relating to an appointments to federal office. And 3, specifically exempted from disclosure by statute other than 552 or 552B of Title V, provided that such statute, and here's some more subsections, A, requires the material be withheld from public in such a manner as to leave no discretion on the issue. So that's important. And subsection B here. And actually it says or. So we've got 2204, subsection A, subsection 3, subsection A and B. Stay with me here. Here we go. And so establishes particular criteria for withholding or refers to particular types of material to be withheld. And then we move on to subsection 4. Trade secrets and commercial or financial information obtained from a person and privileged or confidential. And again, this is talking about restrictions on access to presidential records. 5, confidential communications requesting or submitting advice between the president and the president's advisors or between such advisors. Or 6, personnel and medical files and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. All right, and again, this is all in reference to restrictions on access to presidential records. Now we get into subsection B here, and we have, I'm just going to break this apart again to make it easier to follow because everything has to be a little bit more complicated in the legal system, doesn't it? All right, and then we've got even 2 further subsections here. All right, so let me just make sure I'm getting everything documented properly here so everyone can follow along. I don't want to miss anything. Okay. So subsection B1, any presidential record or reasonably segregable portion thereof containing information within a category restricted by the president under subsection A shall be so designated by the archivist, and access thereto shall be restricted until the earlier of A, the date on which the former president waives the restriction on disclosure of such record, or the expiration of the duration specified under subsection A for the category of information on the basis of which access to such record has been restricted. Or, and our ands and our ors are important here, so either A or B would be applicable, upon a determination by the archivist that such record or reasonably segregable portion thereof or of any significant element or aspect of the information contained in such record or reasonably segregable portion thereof has been placed in the public domain through publication by the former president or the president's agents. All right, so this public domain level is something that could happen, but it needs to happen previously. Now, again, we are in section 2204, restrictions on access to presidential records. We've gone through subsection A, subsection B, and we are down here to another piece of subsection B. Any such record which does not contain information within a category restricted by the president under subsection A or contains information within such a category for which the duration of restricted access has expired shall be exempt from the provisions of subsection C, which is coming up later, until the earlier of, and then they've set out some dates here, which I will not read through, but again, they're referring to prior sections here. We are on section 2204, and they're talking about 2203. Number 3, during the period of restricted access specified pursuant to subsection B1, which is up here, again, if you want to follow along where we're at, the determination whether access to a presidential record or reasonably segregable portion determination thereof shall be restricted shall be made by the archivist in his discretion after consultation with the former president, and during such period such determination shall not be subject to judicial review except as provided in subsection E of this section, which we have not gotten to yet. So we flip along to the next portion, and we are continuing here. So let's keep this in mind. We're in subsection B3, and here's the continuation of that language of subsection B3. The archivist shall establish procedures whereby any person denied access to a presidential record, because such record is restricted pursuant to a determination made under this paragraph, may file an administrative appeal of such determination. So if you want to get access to a restricted record, you can, if you file the proper paperwork. Such procedures shall provide for a written determination by the archivist or the archivist designee within 30 working days after receipt of such an appeal, setting forth the basis for such determination. And that takes us to subsection C. Now, again, I'm trying to keep you with me. We are on section 2204, restrictions on access to public records. We've done A, we've done B here, and now we're at subsection C. And under C, it says, subject to the limitations on access imposed pursuant to subsections A and B, presidential records shall be administered in accordance with Section 552 of Title V, United States Code. And you can take a look at that. That's easily accessible to all of the public online, except that paragraph B5 of that section shall not be available for purposes of withholding any presidential record, and for the purposes of such section, such records shall be deemed to be records of the National Archives and Records Administration. If anyone has been reading through any indictments, this particular organization may look familiar. Access to such records shall be granted on non-discriminatory terms. Now we have subsection 1, now we go down to number 2. Nothing in this act shall be construed to confirm, limit, or expand any constitutionally based privilege which may be available to an incumbent or former president. All right, so we do have some constitutionally based privileges here, but we'll get into more of that later on in the act. Now, subsection D. Upon the death or disability of a president or former president, any discretion or authority the president or former president may have had under this chapter, except for 2208, which we've not gotten to yet, shall be exercised by the archivist unless otherwise previously provided by the president or former president in a written notice to the archivist. And that takes us to subsection E. The United States District Court for the District of Columbia shall have jurisdiction over any action initiated by the former president asserting that a determination made by the archivist violates the former president's rights or privileges. So it would have to be filed in the U.S. District Court in Washington, D.C. if there was a question of any violation of a right or a privilege of a former president. Subsection F, the archivist shall not make available any original presidential records to any individual claiming access to any presidential record as a designated representative under Section 2205, subsection 3, which we'll get to in a minute, of this title, if that individual has been convicted of a crime relating to the review, retention, removal, or destruction of records of the archives. So they're saying you can be denied, they can not make available any of this original material, the presidential records, here, if the individual has been convicted of a crime relating to the review, retention, removal, or destruction of the records of the archives. Next, we have Section 2205, and we have exceptions to restricted access. Of course, we always have to have some exceptions. Notwithstanding any restrictions on access imposed pursuant to Section 2204, which we just went through, and 2208, the archivist and persons employed by the National Archives and Records Administration, again, this entity is pulled out, who are engaged in the performance of normal archival work shall be permitted access to presidential records in the custody of the archivist. Next, subject to any rights, defenses, or privileges which the United States or any agency or person may invoke, presidential records shall be made available. And then we go down here. Pursuant to subpoena or other judicial process issued by a court of competent jurisdiction for the purposes of a civil or criminal investigation or proceeding. So any of these records can be accessed via court subpoena or other judicial process for either civil or criminal. And that takes us to subsection B. To an incumbent president, if such records contain information that is needed for the conduct of current business of the incumbent president's office, and that is not otherwise available, and we're going through the exceptions again for restricted access. C, to either House or Congress, or to the extent of matter within its jurisdiction, to any committee or subcommittee thereof, if such records contain information that's needed for the conduct of its business and that is not otherwise available. And in our final piece here, under the exceptions, the presidential records of a former president shall be made available to such former president or the former president's designated representatives. Again, these are exceptions to restricted access. So, notwithstanding any restrictions on access imposed by the earlier section in 2208, which we'll get into. So that's where that subsection is under. Next, we get into regulations. 2206. The archivist shall promulgate in accordance with section 553 of Title V United States Code regulations necessary to carry out the provisions of this chapter. Such regulations shall include provisions for advance public notice and description of any presidential records scheduled for disposal. 2, provisions for providing notice to the former president when materials to which access would otherwise be restricted pursuant to sections 2204 are to be made available in accordance with 2205, which we just went through. Subsection 3, provisions for notice by the archivist to the former president when the disclosure of particular documents may adversely affect the rights and privileges for which the former president may have. And section 4 here, provisions for establishing procedures for consultation between the archivist and appropriate federal agencies regarding the materials which may be subject to this section of the code. Okay, so these are the regulations. Not quite as exciting, but still incredibly important. And the next piece here is on vice presidential records. And I won't read through all of this because I want you to still be awake by the time we're done here. But I will state the very first sentence here. Vice presidential records shall be subject to the provisions of this chapter in the same manner as presidential records. And then they go through further descriptions here. So all of those records kept by the vice president just need to be treated the same as if they were kept by the president. Next, we have a special note on a rule of construction, which was added by Congress later, just stating that we've got, when it comes to the vice president's stuff here. I could give you a more detailed explanation, but we still have a little ways to go here. So here we go. Claims of constitutionally based privilege against disclosure. This is a really important piece that we'll go through here. So let's pull out these different pieces so we don't, so we can follow along carefully here. We've got subsection A, which will start. And if we have an A, that means we need a B, which we have here, and we need a C. So then we've got a subsection 1 here, and we're going to need a subsection 2. Subsection 1, let's follow along. So 1 and a 2. All right, well, we'll come back to that. Oh, it's getting late. All right, here we go. Making sure I'm in frame here. All right. When the archivist determines under this chapter to make available to the public any presidential record that has not previously been made available to the public, the archivist shall And then we get into subsection A here, which is promptly provide notice of such determination to the former president whose term of office the record was created, and to the incumbent president, and make the notice available to the public. And then here we have subsection 2. The notice under paragraph 1A shall be in writing, and B shall include such information as may be prescribed in regulations issued by the archivist. And that takes us to subsection 3. Again, you can see how using colors can help us keep on task here. 3A, upon the expiration of the 60-day period, except Saturdays, Sundays, and legal public holidays, beginning on the date the archivist provides notice under paragraph 1A, which we can look here, there's paragraph 1A. The archivist shall make available to the public the presidential record covered by the notice, except any record or reasonably segregable part of a record with respect to which the archivist receives from a former president or the incumbent president notification of a claim of constitutionally based privilege against disclosure under subsection B. And that takes us to subsection B here. A former president or the incumbent president may extend the period under subparagraph A once for not more than 30 additional days, excepting Saturdays, Sundays, and legal public holidays, by filing with the archivist a statement that such an extension is necessary to allow an adequate review of the record. So let's make sure that we are following along properly. So that bumps us over to C. Notwithstanding subparagraphs A and B, the 60-day period under subparagraph A or any extension of that period under subparagraph B would otherwise expire during the 6-month period after the incumbent president first takes office. Then that 60-day period or extension respectively shall expire at the end of that 6-month period. So that's exciting, isn't it? All right, so let's take a look here. Again, we are looking at subsection 2208, claims of constitutionally based privilege against disclosure. We've gone through subsection A. Subsection B is next. For purposes of this section, the decision to assert any claim of constitutionally based privilege against disclosure of a public record or reasonably segregable part of a record must be made personally by a former president or the incumbent president as applicable. A former president or the incumbent president shall notify the archivist, the Committee on Oversight and Government Reform of the House of Representatives, and the Committee on Homeland Security and Governmental Affairs of the Senate of a privilege claim under paragraph 1 on the same day that the claim is asserted under such paragraph. Now, as a side note, this may seem like a lot of administrative language, and it is, but that is what the law is. The law is administrative. We have rules and deadlines for everything. And if you want to assert a privilege, if you are being accused of a crime or you've been indicted for a crime, and you want to use a privilege against self-incrimination or some other kind of privilege, diplomatic privilege or governmental immunity, any of those things, you have to plead those out as an affirmative defense. And those have to be pled prior to trial. This isn't legal advice. This is just basic legal knowledge. But anytime a privilege is to be invoked, it has to be pled prior to the using of that privilege. So this section of this statute is stating, that we have a time-sensitive piece to a privilege claim. So if a president is claiming privilege under this particular act, they have to claim it within a certain period of time. And some people may say, well, they should be able to claim privilege anytime that they want. But that's just not how the law works, and it's not designed to work that way. We have to follow not only the substantive law, which is the basics of all of the law, the black letter law, but we have to follow the procedural law too. And some people may say procedural law, those are technicalities, and it's frustrating. And maybe so, but we have to have some way of properly going through the system, or everything would just be willy-nilly. So I just want to draw attention to this particular piece, saying that this is not unusual at all in any kind of a legal situation where a privilege is going to be used. You have to have it used within a certain period of time. It's not unlimited. And that takes us to subsection C1. If a claim of constitutionally based privilege against disclosure of a presidential record or reasonably segregable part of a record is asserted under subsection B by a former president, the archivist shall consult with the incumbent president as soon as practicable during the period specified in paragraph 2A to determine whether the incumbent president will uphold the claim asserted by the former president. Again, these are our procedural rules when we have a question of whether or not a privilege would apply. It has to be set out at the proper time. It has to be approved. These are the procedural rules, which are just as important as the substantive law when it comes to our legal system. We have to have both. We don't work without both. And that takes us down to paragraph C1, which we have just gone through. And so sub 2, C2, and then subsection A. And we will go in here again with another color just to pull these out again so that it's easier to understand the language. Not later than the end of a 30-day period, beginning on the date on which the archivist receives notification from a former president of the assertion of a claim of constitutionally based privilege against disclosure, the archivist shall provide notice to the former president and the public of the decision of the incumbent president under subparagraph 1 regarding the claim. Again, this is more of that procedural requirement when there is a privilege being asserted. Next, if the incumbent president upholds the claim of privilege asserted by the former president, so the current president, saying the past president is trying to assert a privilege, the archivist shall not make the presidential record or reasonably segregable part of the record subject to the claim publicly available unless the incumbent president withdraws the decision upholding the claim of privilege asserted by the former president, or, not and, but or, the archivist is otherwise directed by a final court order that it is not subject to appeal. Again, our procedures when we're dealing with any kind of question about immunity or a claim of privilege. Now we're into, just to recap again, we are in subsection 2208, claims of constitutionally based privilege against disclosure. We've gone through subsection A, B, and we are now at C. Now we're at C2C. If the incumbent president determines not to uphold the claim of privilege asserted by the former president or fails to make the determination under subparagraph 1, that's this one, before the end of the period specified in subparagraph A, okay, the archivist shall release the presidential record subject to the claim at the end of the 90-day period beginning on the date on which the archivist received notification of the claim unless otherwise directed by a court order in an action initiated by the former president under section 2204, which we've already looked at, of this title, or by a court order in another action in any federal court. So again, we have this place where courts can intervene into the situation depending on what's going on. And that takes us then to subsection D. Again, I'm just going to pull this out. These colors don't mean anything. It's just an easier way of following along. The archivist shall not make publicly available a presidential record or reasonably segregable part of a record that is subject to a privilege claim asserted by the incumbent president unless, and that takes us here, the incumbent president withdraws the privilege or the archivist is otherwise directed by a final court order that is not subject to appeal. Subsection E, the archivist shall adjust any otherwise applicable time period under the section as necessary to comply with the return date of any congressional subpoena, or judicial process. So they're clarifying, we've got a legislative act here, we've got rules that have been drafted by an elected body, it have been passed, have been put into place, but there are situations where the president could be involved, the former president could be involved, and the courts could be involved. So they're all interwoven here together within the language of the statute. That takes us to 2209, which is the final section of this act. Disclosure requirements for official business conducted using non-official electronic messaging accounts. This is a newer section to this code and is also very important. So we'll go through each one of these pieces. In general, the president, vice president, or a covered employee may not create or send a presidential or vice presidential record using a non-official electronic message account unless the president, vice president, or covered employee, then we go to our subcategories here, copies an official electronic messaging account of the president, vice president, or covered employee in the original creation or transmission of the presidential record or vice presidential record, or forwards a complete copy of the presidential or vice presidential record to an official electronic messaging account of the president, vice president, or covered employee, not later than 20 days after the original creation or transmission of the presidential or vice presidential record. This has to do again with electronic messaging accounts. That takes us to subsection B, adverse actions. The intentional violation of subsection A, that's this one, by a covered employee, including any rules, regulations, or other implementing guidelines as determined by the appropriate supervisor, shall be a basis for disciplinary action in accordance with subchapter 125 or chapter 75 of Title V, as the case may be. So here we have a very typical language where we have an act, and if you violate what they're saying here, then this is the punishment that you're going to be looking at for that violation. Subsection C, specifically for this section of electronic messaging accounts, they have some specific definitions set out, so we can go through those. First, we have a covered employee. So who is a covered employee just for this section? Again, our definitions of different terms will change for every single section of the law, so you always want to look to the definitions for what it actually means, because it could mean something completely different if you're looking at a different law. So A, we have the immediate staff of the president. B, the immediate staff of the vice president. C, a unit or individual of the executive office of the president whose function is to advise and assist the president. And D, a unit or individual of the office of vice president whose function is to advise and assist the vice president. So these are who are covered by the term covered employee. So we have the vice president, we have the president, or a covered employee. That's who this applies to. And that takes us then to subsection 2, which explains what electronic messages are. The term electronic messages means electronic mail and or other electronic messaging systems that are used for purposes of communicating between individuals. So this is specific to something we might call emails. Subsection 3, electronic messaging account. The term electronic messaging account means any account that sends electronic messages. And that is the end of this statute. So I have gone through every single section here and divided all of the pieces up. I will do a quick review, just a summary here. But this is available online. You can go online very easily, any search engine. This is public information, federal law, and you can look up 44 United States Code Chapter 22, and this is exactly what you will find. Now, I will have coming up a set of videos that I did make going through each piece of this in case anyone needs help falling asleep at night. but I will post those one at a time as the algorithm permits. But I do have one already posted for today, and I highly recommend if anyone has questions on this presentation to please go and leave those questions under those posts, and I will get to them as soon as possible and try to answer to the best of my knowledge. Now, I have gone through all of these pieces, so let me just do a quick recap here of what we're looking at. This is the presidential records section of the federal code, and this comes from Title 44 of the federal code, the United States Code, also called the Federal Code, and under Title 44, Public Printing and Documents. Now, this is the title. These are all the chapters included in this particular section of the law. And so if we go down to Chapter 22, we will find presidential records, which is this particular act, this law that I have been talking about. So you can go online and look it up. There's multiple places where it's available, and you can take a look at it and go through it. You can refer back to any of my video posts if you want to kind of pull apart the statute in a similar way. I highly recommend to all students or anyone who is learning about the law or trying to figure out the law to use a color coding system to pull different parts apart, because the black letter law, the black and white, can be very overwhelming. So this is just another example of what you might find when you pull the search up. I wanted to pull a couple copies out. So if this comes up on your search, this is also permissible, completely accurate information as well. If this one comes up, again, 44 USC Chapter 22, Presidential Records. And this was written and passed by Congress, as all of our laws are required to be done, procedural as well as substantive law. And that takes us then to what I have been talking about, which is going through the actual language of the presidential records piece of the law. Now, I will just do a quick summary here. I won't go through it in detail since I've already done that, but we do have a definitions section, and I caution everyone when you are going through the law to make sure you check your definitions, because every single section of the law, every act, everything that's filed, the words mean something different, and that's something that's just within the legal system. And so what we have to do is set out a key, and our key that we use in the legal system are our definitions. And so any specific words that we are using throughout the language of the law, we are referring to these specific definitions. So whatever documentary material means in a different code section, if it's under a criminal code section or a civil code section or whatever, if you see that term documentary material, it's going to mean something completely different than what it means in this section of the code, because every section of the code will set out definitions specific to that section. And that goes into legislative intent and how Congress drafts the law. So we go into definitions here. Specifically, we talk about documentary materials, what presidential records are. That's important. And an explanation of that. Again, I'm just doing a quick summary. I've already kind of gone through everything. But presidential records, what are they? And then personal records, and there's a difference. Who our archivist is. The archivist plays a major role. So whoever that person is the one that's in charge of implementing the statute. Also, the term former president, who does that encompass? Next, we've got ownership of presidential records, and Congress very, very clearly set out that the United States retains complete ownership, possession, and control of presidential records. So the ownership is on the United States of America. And 2203, management and custody of presidential records. So who gets to have custody and control? Congress sets it out right here. And who's in control of management? It's also set out throughout all of these subsections. They go into very specific details of who is in charge of managing and controlling these records. which takes us to Section 2204, restrictions on access to presidential records. So, of course, we have to have some restrictions, as with all laws, when we're dealing with sensitive information. And here they set out those restrictions on who is restricted regarding access here, which I've already gone through, just doing a summary. And the restrictions are pretty detailed. And we'll move on to exceptions to restricted access. So there are some exceptions, but that's a lot of this act is set up on what the restrictions are. So we've got exceptions to restricted access. We have 2206, which goes into regulations. 2207, which goes into the vice presidential records. A lot of people probably don't realize that the vice president has to also maintain the records, the same as the president does. And all of these rules apply to the vice president just the same as they do to the president. And we've got a note of rule of construction, which was a bit added by Congress later on, just explaining further about those requirements by the vice president when keeping records as well. Next, probably one of the most important parts of this act, in my humble opinion, is Section 2208, which are claims of constitutionally based privilege against disclosure. And Congress was very clear when they walked through the wording on this, exactly what can be done when someone is claiming a constitutionally based privilege. Now, I was talking earlier about having to, in any kind of a case, if you are asserting a privilege or you are asserting some kind of immunity, that has to be done. We call those affirmative defenses. Those have to be done before trial. And so this section of the code here sets out also that these kinds of privileges have to be asserted within a certain time period, very typical of any kind of legal statute. And that takes us to disclosure requirements for official business conducted using non-official electronic messaging accounts. This is a more recent addition to this particular federal code, and it goes into the different definitions specifically of who is involved. So the employee, the vice president, and the president, and then also what electronic messages are and electronic messaging accounts. So this explains very clearly, Congress set out when it comes to any kind of our electronic messaging situations, what can and cannot be created and the parameters within that. So that's an overview of this particular section. And again, I'm sorry I had to turn off comments, just needed to do that in order to be able to really focus on the content and the material I have here. If anyone has questions, again, I have and will be posting a set, I believe it came out to five videos going through this, and I just put them out in 6-7 minute increments, as more than that again would put anybody to sleep. I might have put myself to sleep, quite frankly, but I will have them available for anyone that needs to refer to them. And please do ask any and all questions on any of my previously posted videos about this live if you have questions, and I will do my best to answer them. But thank you all for coming and being here and being interested in the law. That's my favorite thing to talk about. So I hope you'll join me when I do another live. I'll probably post a question maybe next week and see what kind of a topic people might be interested at that point. I do have a couple of options, and again, I'll just share these with you to see if anyone's interested, and you can kind of leave a comment in the various sections of different videos. I do have also the Classified Information Procedures Act, which I could go through and explain that. If anyone is interested in that, let me know. I also have, I don't know if anyone's interested in this, I also have the appearance bond, a personal recognizance release for United States versus Donald Trump. And this goes through all of the things that happened during his arraignment and different pieces that were checked on. And I think that this is interesting because it sets out any kind of special conditions for bond that were set out, but more importantly, any special instructions. So we do have some special conditions and instructions that were added on. Also any kind of sanctions if there's a violation of any of those. So, and then that's just set out here, the case number with signatures and the magistrate that oversaw the arraignment. So, and again, we have particulars on a Brady order that was given, and I can go into details of what that is if anyone's interested. Also, defense counsel and so on. So we do have some special pieces that went into this initial appearance and arraignment. I have put out a video explaining what initial appearance and arraignment are for anyone who's interested. But if anyone would like me to go through this particular document, I certainly can. And again, I would be happy to do that. And I also have the brand new U.S. Supreme Court cases that just came out, Smith v. United States, along with the ICWA cases. So if anyone is interested in me going through that, please just let me know on any of my other posts. So thank you again, everybody, for being here. It's been fun, and I will hope to catch up with you all next week. Have a great night.